Yeah, thank you so much for having me. Today I want to concentrate on more like a detailed recap of the subject of Ubuntu Ulamu and the law, or what you want to call Ubuntu and the law, towards the new constitutional dispensation. So I have quite a number of materials I'll be referring to. All these, I hope I have enough time to kind of go through some of them, and particularly also in light of some substantive frameworks that have developed over a period of time that I think would be very good for purposes of future jurisprudence for our country, but also for the world. So I will go probably as fast as I can, but let me start by talking about the sections, how I want to proceed. For example, section 1, in light of the discussion, the conceptual foundations, what Ubuntu is, in light of the etymology, in terms of the variants, in terms of the core values, and also in terms of definitional debates that have ensued in light of the question of Ubuntu. And then section 2 would involve things like the theoretical framework in terms of the philosophical and legal theories underpinning the thesis in terms of what would then inform the subject of Ubuntu. And then section 3 would be the historical and constitutional architecture in terms of the colonial encounter, arguing in terms of the repugnancy doctrine and the constitutional embedding of Ubuntu values and how it has been played out. And then section 4 would be in terms of the Ugandan jurisprudential corpus, in terms of some of those key cases, and also the ratio disdendi, and in terms of what they call the Ubuntu principles that have been extracted in terms of how it has been played out. And then section 5 would be in light of the comparative jurisprudence in terms of countries like South Africa, Zimbabwe, East Africa, particularly those countries within East Africa, and then the global resonance, how it has actually been also played out in terms of the global perspective, something beyond Africa. And then section 6 would be in terms of the challenges, the criticisms, and some of the rebuttals that I may want to do in terms of some of those propositions that may have been have actually taken root in one way or the other, and the three major objections on how the thesis dismantles them in terms of that layout as well. And then section 7 would be in terms of the recommendations, and then the normative proposals in terms of the thesis prescriptions and their justification. And then section 8 in terms of the anticipated challenges, in terms of the questions that may come to your mind or to my mind, and what substantive answers that may come out in terms of how to address some of those. It will be some kind of mapped analysis in terms of a defense flow, if you want. And then section 9 would be in terms of what I would call the master citation index, which will entail every key authority that you may want to glance on in terms of the subject of Ubuntu. So I have taken some trouble to do extensive research. As I told you, this has taken me about 9 years now in the running, and I'm comfortable enough to go with it with the help of God. But I want to have a discussion in terms of a one-to-one discussion so that we can all enjoy the subject of Ubuntu and how it has played out. So, as I said, for me to be more authoritative, it would be very prudent for me to be referring in light of what is written, so that you can have an authoritative discussion. It is something I can speak off head, but I prefer to narrow down. When you narrow down in terms of what you've summarized, then you may not, you may not move away from so much away from the core subjects in terms of what people would appreciate. And for purposes of this analysis, I would argue that Ubuntu is not merely a cultural sentiment. It's a justiciable, it's a constitutional, it's a moral grounded legal principle capable of resolving contemporary jurisprudential dilemmas in our country, but also in most countries and beyond. And therefore, this proposition is going to be running through the entire discussion this evening. So by way of a conceptual analysis in terms of the foundation, I would argue that the term Ubuntu, some people want to call it Ubuntu for the sake of Luganda, Ubuntu in Banyankole perhaps, and the Bachikas and the Manyoros and the Batoro dialects, and then Bumuntu amongst the Kisukumuka, and then the Kahaya, and then things like Bamoto amongst the Babanji, And then you could also argue in terms of Ubuntu in light of the Chikongo or the Gikwesi, and then Umundu perhaps in the Chikuyu. You could also argue in terms of Umuntu in terms of the Malawi, or Vumuntu in terms of the Shisonga. So universally, this concept, regardless of how we are pronouncing it or what we're using, it gains a universal aspect. So the the universality here refers to the quality, the potential or instance of being human, the concept of being human, embodying the aspect of personhood. That should be very clear. The aspect of personhood, the aspect of humaneness, and the requisite relational and even moral qualities that these notions do expose. So that is extremely important in terms of giving us a foundation in terms of the etymology, if you like, in terms of the concept foundations of that argument of the word Ubuntu or Ubuntu Mlam. And then when you argue in terms of the core translations, you would look at concepts like the definitional content would then entail one to mean that Ubuntu is I am because we are. The relational ontology of selfhood grounded in community, and that thing that was proponent by Bishop Desmond Tutu way back in 2013. And amongst the Bantu root, perhaps you could also argue that it is derived from the Bantu cosmology. It's part of the implied individual ontology of Bantu peoples, and that was proponent by Munro in 2004. And particularly one of the biggest scholars or perhaps proponents of the concept of Ubuntu was Archbishop Tutu. No wonder his definition of the concept of Ubuntu would mean a person with Ubuntu is open and available to others, affirming of others, and does not feel threatened that others are able and skillful. That was said by Bishop Desmond Tutu way back in 2016. And when you look at people like Justice Sachs, Ubuntu envelops the key values of group solidarity. Yeah, the compassion, the aspect of respect, the aspect of human dignity, conformity to basic norms, and collective unity. And that was propounded in the case of Ara versus Mokwanyani, which was a very important case in South Africa, which had to do away with the death penalty. And when you argue in terms of Justice Magkoro, the argument here was that Ubuntu is one of those things which you recognize when you see it. Imagine that is component that you cannot even define it, but you can see it. When you look at it, you can know this is Ubuntu. And the aspect of recognizing the concept is inherent. It's inherent. It resists what you call rigid definition. So you cannot put it in a corner and say that is Ubuntu. You look at it, and by mere looking at it, you can tell and know this is the concept of Ubuntu. And it's a philosophy, but it's also a life, as we shall see. And then when you look at the concept in how Ugandans may want to argue the concept of Ubuntu, for example, amongst the Central people, the Baganda people, when they argue in terms of Ubuntu Bulamu, they look at it in terms of humanness, the aspect of goodness. You say, Omuntu, alina Ubuntu Bulamu, weeyisenga omuntu, behave like a person. I was telling people that even the Ugandan unique way of greeting, the Ugandans have a unique way of greeting that when you give them their hand, they hold and then it locks and then hold and locks. I'm doing it alone, so it looks funny, but when you're having someone, you know what I'm talking about. That assurance, the self-assurance, that locking creates that comfort of, listen, I am your brother or I'm your sister, we are one, we are intertwined. Even amongst the certain tribes, amongst the Bantu people like the Basogas, when they greet, it's not a question of simply greeting. The European concept of greeting has taken another concept altogether. It's a question of hi, what's up, things like that. But the original concept of how, for example, the people of Usoga, greeted in terms of how they interacted with one another. You say, Mulimucheyo, tuliyo, mwebale kale, baliyo, obukoko bulungi, obwana bulungi, gatona ye gatona, mwebale. It doesn't just end there. You're giving someone an assurance. You're saying, how are you? I'm fine. How are your people? I'm fine. How is madam? Is there? How is the grandmother? Is there? How are the young ones? Is there? How are the chickens? How are the hens? How are the goats? How are the cows? All those components. And then it doesn't end there. It ends with that assurance of as the person goes, kale, obatuwonera, mwebale, It goes on. It's not fiction. It's not mechanical. It is bond, realistic bond, the concept of oneness. Greeting was an extension of humanity, was a bond of togetherness, was an assurance. It's not a question, hi, that artificial, that mechanical look. It's a question of I'm looking forward to your being, but also to your personhood. And the personhood extend beyond that the individual, and it had to do with the entire society. So that's extremely important for us to understand the concept of this analogy called Ubuntu. And then when you look at Brooklyn's position, Brooklyn's argued that it does not matter that different African languages have different names of Ubuntu. Yes, its basic meaning and worth remain the same for all Africans. That according to, and which is very true. And I made that realistic example last time when I was giving an example of what Shakespeare was saying in Romeo and Juliet. He said that a rose, assuming that is a rose, he says a rose would still be called a rose or any other name, but still smells sweet. So the concept of naming it, we call it another name, call it what? Call it purple blue, or call it yellow, or call it whatever name you want to call it. Without even calling it in terms of color, but in terms of the name of the botanical name, perhaps of the flower, it will still smell sweet even if called any other name. So the concept of naming then loses fundamentality in terms of definiteness. It only helps you to attach locality, but it would mean, probably doesn't mean, it would mean the same thing in different areas, on different jurisdictions, on different traditional setups. So we are saying that the concept of Ubuntu, whether we are calling it Ubuntu Gulamu, whether we are calling it Ubuntu, whether we are calling Breaksback, whatever you want to call it, would have different namings, yes, but it will entail the same thing. So the component, that's what Brooklyn was trying to imply in terms of that. And then the aspect of Langer J, it makes this proposition and says a culture which places some emphasis on community and on the interdependence of the members of the community. You see that component? And I think it was Dr. Martin Luther King who said, I cannot be what I am until you are what I am. For whatever reason, we are inextricably bound. We are linked up with one another. We are deeply connected. Your well-being is my well-being. That kind of concept. And this is the point that all these individuals are trying to emphasize, the culture which places emphasis on community and the interdependence of the members of the community. And that was purported in S versus Mukwanyani. And when you look at Justice Mohammed as well, the argument Justice Mohammed proposes is that it expresses the ethos of an instinctive capacity for and the enjoyment of love towards fellow men and women. That again was proposed in S versus what? Mukwanyani, which was particularly a South African case. So all these individuals were able to see the concept of Ubuntu in that wonderful discussion. So the core values of Ubuntu would be things like the aspect of group solidarity, yes, and communal interdependence, yes, and the aspect of compassion, the aspect of empathy, the aspect of care for other quality of life, the aspect of human dignity, as rational, not merely individual, the aspect of respect and recognition of personhood, the aspect of reconciliation and restorative justice over retributive punishment, the aspect of collective responsibility and even social accountability. All these will capture the concept of the aspect of community to basic community, for example, the aspect of transparency in terms of sharing, but also in terms of what? In terms of hospitality. So the component here would be, in terms of a definitional challenge, you would argue and say that the notorious difficulty in defining Ubuntu itself is a feature of the concept itself, yes, not a weakness, yes. And as Makoro observed, that defining an African notion in a foreign language, defies the very existence. She was able to recognize that. The fact that Makoro observed that defining an African notion in a foreign language defies the very essence of it. That's why I say it's something you look at and you cannot, you cannot define it in the concept of that. So you it's almost of us in a way, shapeless and yet real. So the aspect is that my argument here is to provide an adapting concept of Ubuntu as a normative theoretical principle rather than as a rigid legal rule. Okay, it is the deliberate jurisprudential choice that strengthens and not weakens my argument in terms of what I'm talking about. And then the aspect of also, it's also important for you and I to comprehend that Ubuntu has actually been viewed not merely as an African concept, but also as a worldwide view in terms of African societies as a determining factor in the formulation of the perceptions that influence African society conducts. Again, that was proponent by Brooklyn. Okay, so the broader conceptualization means that Ubuntu cannot neatly categorized. Any attempt in terms of a strict definition would actually be a simplification of a more expansive, a more flexible, a more philosophical, a more accommodative idea that again was proponent by Makoro way back in 1988. So my intention here is I deliberately resist the trap of definition or closure. Yes, instead, I intend to articulate an Ubuntu-based moral theory in terms of growing out of indigenous understanding of the aspect of Ubuntu, in terms of fairly precise, in terms of clearly accounting for individual liberty, but also in terms of readily applicable and contemporary social legal connections in terms of the problems that are issued in terms of the concept of Ubuntu. So that is extremely very important as well in terms of the subject that we're talking about this evening. Now, in terms of what may come for purposes of theoretical framework, in terms of those of you who want to take it on another, perhaps a scholarly of an academic level, there are substantive scholarly frameworks that can be laid in the concept of Ubuntu, and I will try to go through as many of them as possible. I hope I have enough time. I intend to do this within not more than an hour so that I can capture as much as possible within this time. I would argue that the argument here is that I intend to construct a specific normative theoretical account of Ubuntu, yes, in terms of articulating the actions as a right insofar as they prize communal relationship in which people identify with each other. So that is extremely important. And share a way of life and exhibit perhaps exhibit aspects of solidarity towards one another and even care about one another's quality of life. So this principle has, you could argue, in terms of a Southern African Bantu pedigree, it provides in terms of a new account of morality grounded in the value of friendship. The aspect of Ubuntu would equal communal love, and suggest a novel conception of human dignity as the foundation of human rights. Fundamentally important in terms of the concept of Ubuntu. As a core argument, my intention is that it's very, very important for us to argue that the actions have to be right in terms of, or even counter Ubuntu humanness in terms of a person, insofar as they prize what they call communal relationships. Yes, so ones in which people identity with each other share a way of life in terms of exhibiting solidarity towards one another and care about each other's quality of life in terms of that component. So, my friends, this is a beautiful concept of Ubuntu that we're just beginning. We're going to enjoy the discussion. I said this is going to be a discussion. Okay. It's also important to us to acknowledge and understand that Ubuntu can also be related in terms of a human aspect of dignity, in terms of the right foundation. We could argue that the Ubuntu-based concept of human dignity holds that typical human beings have dignity by virtue of their capacity for communal or friendliness, for example. Yes, so human rights violations are egregious failures to respect this, this capacity. They take the form of extraordinary unfriendly behavior that is not required to protect the victims of another's proportionality unfriendly behavior. So we are seeing that particular point also being made. So the conception in terms of forward-looking, in terms of the consequentialist, in terms of direction, rather than backward-looking in terms of retributive, we are saying that it directs moral agents to consider the likely consequence of behavior and not to determine whether behavior is actually appropriate solely in the light of facts about the past in terms of that context. So a critical distinction therefore is extremely important from retributive approaches that I intend to lay, but leverages to critique certain judicial reasoning in terms of the concept of Ubuntu. Now, fundamentally in terms of the theoretical framework, because that is where we are now, it's important for us to understand about three fundamental philosophical objections and their rebuttals. In terms of, for us, in terms of the aspect of vagueness, because the argument could be, Ubuntu could be construed as something that is vague. I just told you the aspect of it being amorphous, shapeless, if you like, and the critics would argue that Ubuntu is too vague, yes, to serve as a legal standard, okay? And the thesis in my contemplation of this particular argument will respond by articulating a precise moral principle, the promotion of communal relationships grounded in a shared identity, solidarity and even care. So the standard is more determinative than many accepted legal concepts in a question of reasonableness, or public interest, for example, in terms of that argument. So I rebut that aspect of vagueness in terms of that context. And then the aspect of collectiveness also as a discussion in terms of an objective. I could argue that critics could argue, for example, that Ubuntu suppresses individual rights in favor of the other groups. Yes, and my intention in doing this, I will invoke Greek's restricted communitarianism as a framework that actually acknowledges the social nature of persons without denying the ultimate moral status or and liberty of the individuals. So Ubuntu, my friends, does not negate individuality. It contextualizes it within the community. That's fundamental in terms of our discussion as well. And then the aspect of anachronism. Critics would argue that it belongs to a pre-colonial society and inapplicable in terms of modern pluralistic states, for example. My argument here would demonstrate that Ubuntu values are embedded in our constitution in terms of Ugandan 1999 constitution through specific provisions, and they're reflected in terms of contemporary judicial decisions and capable of addressing present-day dilemmas in terms of reform, in terms of deadly force, but also in terms of political power distribution. So those are some of the things that I lay bare as I begin to go. So fundamentally, in terms of the key theoretical frameworks, in terms of those that I've referenced, I would argue in terms of Goethe's restricted communitarianism. Yes, Kwame Goethe, his framework holds that a person, that persons are actually constituted in part of the community, but retain irreducible individual moral status. So Ubuntu does not demand total communal subordination. No, the individual's dignity is actually preserved within, not dissolved by. So the community, it's not dissolved by the community. So this is the most important internal philosophical architecture of my discussion, my friends. And then if you argue in terms of the random communication theory, I would argue that it examines, for example, how communication patterns within African communities, yes, replaced and transit Ubuntu values across generations, sustaining communal ethics informally and even formally. And then if you argue in terms of the cognitive dissonance theory, you could look at it in terms of applied to analyze the tensions between Western important legal frameworks, yes, and indigenous Ubuntu values, explaining how actors within the legal system navigate competing normative demands. And that is extremely important as well. And then if you look at it in terms of another theoretical framework, in terms of the restorative justice theory, you could argue that Ubuntu as a natural precursor and philosophical foundation for restorative approaches both advocate in terms of acknowledging guilt, showing remorse, asking for and even giving forgiveness, and where required paying reparations as a prelude in terms of reconciliation. That was also talked about by Meruthi way back in 2006. And then if you argue in terms of the communitarian theory, this was promoted heavily by Mbiti and Ramos. So where he says, I am because we are. So the Bantu ontology of personhood as rational. Personhood is actually conferred through communal recognition and participation, not merely through birth. Well, that's fundamentally also wonderful in terms of the contextualization of this discussion. And then if you argue in terms of the normative philosophical jurisprudence, then you could argue that my intention here is explicitly a work of normative philosophy. Yes, its aim is not to describe Ubuntu anthropologically, but to construct a moral theory a jurist could actually use to interpret case law and even develop constitutional jurisprudence. So that becomes very important in terms of the discussion, again, for those of you who are listening in. Now, I would like to continue to what I argued in terms of section 3. Remember, we had different sections where I read them to you as we were beginning, and I'm trying to go one through them. I hope I will have the time to discuss as much as possible so that we can understand everything in light of the discussion tonight. Okay, section 3. When you're arguing section 3, we could look at it in the context of a historical and constitutional architecture, yes? And when we argue that, then we have to be very careful to look at Ubuntu before colonialism. Prior to the colonialism, for example, in terms of Ubuntu customary law, there was primarily, yes, indeed, the only source of law as far as Africa was concerned, as far as many of our society was concerned. So many aspects of life were actually governed by customary law and the traditional institutions, community governance and even dispute resolution, and land tenure, family relations and criminal accountability were all regulated through Ubuntu infused in terms of customary law as a framework. We have no doubt in terms of that. But as we proceeded, we could argue that the colonial encounter, in terms of the repugnancy doctrine, for example, the colonial encounter introduced what they call the repugnancy clause, if you remember that. The doctrine provided that customary law would actually be applied to courts only insofar as it was not repugnant to justice and morality, or if it was inconsistent with any statutory provisions. Fundamentally important because now those were now the seeds being sown. So the doctrine devastated the legitimacy of Ubuntu-based customary norms, if you can recall, constructing a hierarchy in which Western European legal standards were actually treated as universal, while African communal values were actually positioned as primitive, contingent, and even dispensable. And that is something, again, you have to put behind our brains as we argue that. So the aspect here was the effect of collectivism. Yes, as an impact, repugnancy doctrine enforced a shift from Ubuntu's communal ontology towards a Western liberal individualization in terms of separating the individual from the community in terms of the law. Fundamentally important. And then the effect on Ubuntu institutions, the aspect that traditional authorities in terms of customary criminal law and community-based dispute resolutions were either subordinated to statutory courts or declared repugnant. Fundamentally also important in terms of that. And then the aspect of the ideological impact, it created what they call a bifurcated legal system in which Ubuntu values could only enter formal law through filter of Eurocentric standards in terms of a filter designed to exclude them. Again, we are seeing that being played out again. And then in terms of the contemporary relevancy, we are arguing that the repugnance of the doctrine's legacy explains why Ubuntu remains underutilized in Uganda's courts despite its constitutional grounding as a central argument for the work that I'm presenting for you this evening. Now, listen. In terms of the constitutional bedding of Ubuntu, in terms of the values of Uganda, we could argue that although the word Ubuntu does not appear, expressly in terms of the 1995 Constitution, the thesis that I'm trying to present tonight demonstrates that its values are constitutionally embedded, and the following provisions are the primary constitutional anchors in terms of that. And these are the ones that I want to lay bare again in terms of that particular concept. First of all, we could argue in terms of Article 126.1. 126.1, where we are saying that in terms of Ubuntu connection, the administration of justice must actually reflect the values, the norms, and the aspirations of the people. And this primarily Ubuntu gateway, demanding that judicial decisions reflect an indigenous communal values rather than exclusively Western liberal frameworks. We shall give that to them. And then if you argue in terms of Article 21.1, then you are arguing that equality and the freedom of discrimination, for example, reflecting in terms of Ubuntu's insistence on equal human rights within the community. We shall also give that to them. And then if you argue in terms of Article 24, then we are saying that respect for human dignity and the protection from inhuman treatment, directly echoing Ubuntu's foundational value in terms of the human dignity as a rational capacity. We shall also give that to them. And then we argue in terms of Article 33, where we're saying the rights of women, for example, that are laying in terms of what they call the Ubuntu-based collective thinking, weaponized historical against women. In terms of Article 33, that is corrected by this, by actually imposing communal obligations against gender equality. So we're also giving that to them. And then you argue in terms of Article 43, where we're saying there are limitations on rights that are justified only by public interest. So Ubuntu provides what we call a communal framework for determining when individual rights may actually be limited by for collective welfare. We shall also give that to them. And then if you argue in terms of Article 128, we are saying that the independence of the judiciary, for example, in terms of creating it will be necessary for Ubuntu values to be genuinely applied without political interference. We shall also give that to them. And then if you argue in terms of the national objectives and directive principles, then we're also saying that the preamble and the national objectives embedded collective responsibility, social justice, and even communal welfare. The legislative expression of Ubuntu philosophy then is also eminent there. We shall also give that to them. Then you argue in terms of Section 15, subsection 1 of the Judicature Act, where we're saying that courts are mandated to apply customary law, providing a direct legal pathway for Ubuntu principles to enter a formal adjudication. We shall also give that to them. So we are saying in substance that in terms of the early constitution written sources of Ubuntu, for example, if you argue in terms of South Africa in the 1995 interim constitution, in its post-amble, it expressly invoked Ubuntu as part of the basis for the Truth and Reconciliation Commission. Yes, and the principle there is a need for Ubuntu, not for victimization, became the constitutional mandate for restorative justice over retribution. Okay, and so if you look at Uganda 19 Constitution, though not using the term explicitly, was actually contemporaneous with the constitutional Ubuntu discourse and actually embeds the values through the provisions that I've just noted above. We shall also fairly give them to them, but be careful because we shall go and discover the problem as we proceed. Now, let us look at section 4 in terms of the Ugandan judicial corpus. I would argue in terms of the architecture of Ubuntu, in terms of Ugandan courts, and I'm saying that the intention of this is to map out the application of Ubuntu in terms of Uganda's judiciary across the multiple domains, yes, in terms of constitutional law perhaps, in terms of family law, in terms of criminal law, in terms of contract law, in terms of land law, in terms of public interest litigation. And I would argue some cases to constitute what I would argue as primary jurisprudential corpus in terms of this discussion, and in terms of with mastered precision in terms of how it has been played out. So permit me go to some cases that discuss the concept in terms of how they've been played out. In terms of, you could argue in terms of Mifumi Limited and another versus Attorney General. You could argue that the ratio disdain here had to do with the practice of requiring refund for bride price upon a dissolution of money that was, marriage, which was actually declared unconstitutional, and it violated the women's right and equality. So the court held that marriage must be grounded in mutual respect and dignity in terms of communal values, not commercial exchange. As an Ubuntu principle, we are saying that Ubuntu's insistence on human dignity and communal respect demands that marriage actually be treated as a relationship of persons, not simply property. So court gave judicial force to Ubuntu rejection of commodification of these human beings. We'll give that to them. And then if you argue in terms of Salvatore Abuki versus Attorney General, we are saying that the ratio disdain in this particular concept had to do with the provisions of Witchcraft Act authorizing banishment were actually declared unconstitutional in terms of banishment. So the physical exclusion of a person from the community was actually held to violate the right to dignity and freedom of movement. So the court emphasized that the cruelty serving a person from their, from their communal bonds, was no go in terms of that component. So in terms of an Ubuntu principle, we are saying that Ubuntu, in terms of Ubuntu ontology of personhood as a community, constituted, or even makes banishment as a profound violation. Yes, to remove a person from their community is an attack on the very source of their personhood and identity. Fundamentally important in the concept of that soundbite for the question of Ubuntu. And then if you look at cases like Sulian Chigura and 14 others versus Attorney General, where the ratio disdain here would be that the mandatory death penalty or the death sentence, for example, are declared unconstitutional. The court held that removing judicial discretion in sentencing violated the due process of dignity, and described, as described in the discussion that I'm presenting, we're saying that the given paradox here is the aspect of losing by winning. Yes, so the appellant won, but the constitutional court, the appellant won the constitutional argument, but many retained on death row pending re-existence. So we are saying that there was a win in this concept. The Ubuntu principle here would be that Ubuntu's restorative philosophy demands that punishment accounts for individual circumstances, yes, and communal context and possibilities of rehabilitation. So it was incompatible with the aspect of mandatory because that became mechanistic in terms of the sentencing. So Ubuntu, as an alternative to death penalty, is developed as a specific recommendation in terms of this particular argument that I'm presenting this evening. And then you could look at another case of Uganda Association of Women Lawyers, what they call FIDA, versus the Attorney General. And the ratio disdain in this particular issue had to do with the provisions of the Divorce Act that discriminated against women in divorce proceedings, where these were declared unconstitutional. So the court held that the equality in family dissolutions mirrors the equality in family formation in terms of that argument. And then the principle here was to the effect that Ubuntu, in terms of a communal ethnic, demands that women be treated with full persons within the community. Yes, so they're not subordinated members whose legal rights depend on the agenda. So the case operationalizes the aspect of Ubuntu dignity principle in the domain of family law. And then if you look at cases like law advocacy for women of Uganda versus Attorney General, the ratio then had to do with the female genital mutilation that was declared also unconstitutional. And the court held that that FGM constitutes torture and an assault on the physical integrity and the dignity of a woman. And therefore, the Ubuntu principle here was that Ubuntu demands that no cultural practice, even one clause in communal tradition, may actually be used to violate the bodily integrity and dignity of persons. So Ubuntu transcends harmful customary practices and does not protect them. Fundamentals, again, in terms of this component. Now, if you look at Bruno Chihuahua and Ivan Serunkuma versus and Juliet Namazi, Bruno and Ivan Serunkuma and Juliet Namazi, the component here in terms of the case that played out here, in terms of the ratio disdain, the customary marriage must meet requirements of consent and capacity. So the court refused to recognize a marriage where consent was not freely given, holding that personal liberty cannot be overridden by family or even communal pressure. So the aspect of Ubuntu here was to the effect that Ubuntu does not sanction coercion in the name of community, Genuine Ubuntu requires that communal practices do affirm, not negate, individual agency and dignity as provided by Jerky's restricted communitarian in terms of direct application. Fundamental in terms of the playout of Ubuntu here. Then you look at the case of Besti Kemugisha and Mabo Komontale. In terms of the racial disdain here, the court addressed competing claims in a matter involving royal family relations and intersection of customary and even constitutional norms, affirming that culture, dignity, and even constitutional right must actually be read together. And in terms of the Ubuntu playout, we are saying that Ubuntu's communal solidarity must actually operate within constitutional limits, and the community's cultural norms cannot override individual constitutional rights, but the constitution must actually be read in light of Ubuntu values where possible. Fundamentals in terms of that. And then you look at another case in terms of the Mwenje versus Migade. If you look at that case, you could argue that the racial disdain here, the case addressed the aspect of customary law norms in the context of property and even in personal obligations. Okay? And then the demonstrating the regional dimension of Ubuntu-based customary jurisprudence across East Africa. And in terms of the principle, we are saying that Ubuntu's normative reach extends beyond Uganda's borders in terms of East African jurisprudence that has actually shared customary heritage, that Ubuntu scholarship can actually be shown to draw upon the comparative jurisprudential this development in terms of this aspect as well. So again, fundamentals and very important. So the racial disdain here was very, very evident in terms of how the Ubuntu played that. If you look at cases like Kabali versus Kajubi, then you would argue that the customary law norms here governing aspects of property and even customary obligations were examined in the context of East African jurisprudence, illustrating how regional reach in terms of Ubuntu-based legal reasoning could also reach. And the Ubuntu principle here demonstrated that the Ubuntu jurisprudence is not exclusively Uganda, okay? It's an East African jurisprudence resource with regional authority and application in terms of how it was applied within that particular court. So I could go on and mention all the different types, but then the most important thing here is perhaps to create some other cases like the ones that played out in the north, for example. Talk about the Ubuntu in action in terms of the Joseph Kony case in the north. We are saying that the Matoput, for example, as a ceremony among the Choli people, is described within this context as a perfect embodiment of Ubuntu in terms of Ugandan customary practice. But we are saying that Matoput, literally meaning drinking the bitter herb, is a restorative justice mechanism which perpetrators and victims come together before the community in terms of acknowledging, in terms of reparation, in terms of reintegration. So the concept in terms of the Joseph Kony case raised profound questions. Can Ubuntu-based restorative justice in terms of Matoput coexist with international criminal accountability, for example? That's something we need to look at. So the Matoput in terms of the Ubuntu question here as Ubuntu litmus test, I would argue that Matoput demonstrates that Ubuntu-based restorative mechanisms are actually capable of addressing even the most serious violations of international humanitarian law, and that their exclusion in favor of a pure retributive ICC provocation or prosecution case reflects a cultural imperialism that I intend to challenge in terms of this jurisprudential discussion again. So in terms of, we could also play out in terms of how Ubuntu has actually played out in contract law, in terms of other cases, in terms of Ubuntu, also in terms of other institutions, for example, as a model. So all these are components of how Ubuntu has actually been played out in terms of the playout. Now, when you look at the comparative in terms of Section 5 now, we are arguing that Ubuntu, for example, if you argue Ubuntu in terms of the different jurisdictions, particularly if you're talking about it in terms of South Africa provides the richest comparative jurisprudential resource in terms of Ubuntu question. And it was explicitly invoked and developed by the Constitutional Court of South Africa from the very foundation of its apartheid constitutional order, if you recall. And if you look at the case of Mukwanyane, which is the locus classicus here, the death penalty was actually declared unconstitutional, and each of the 6 majority judges invoked Ubuntu. Justice Sachs described Ubuntu, for example, as a shared value, an ideal that runs like a golden thread across cultural lines. The case stands as a global foundation in terms of Ubuntu jurisprudence of authority. In terms of the Ubuntu takeaway, the Ubuntu insistence on human dignity, in terms of solidarity, in terms of communal values, was very evident, and it was necessary for a human being because it makes state-sanctioned killing of any person illegal, and even a guilty one. An Ubuntu violation, for example, retribution became foreign to Ubuntu's forward-looking restorative aspect in terms of as a forward or as a go ahead. So those are fundamentals. And then when you look at the particular judgment individuals, the judges who played out in Ara versus Mukwanyane, fundamentals and it's extremely played out. Look at what Justice Langa said in Mokwanyane. He said a culture which places some emphasis on community and on the interdependence of the members of the community is the concept of Ubuntu, the aspect of that interconnection. Look at Makoro in the same case in Mokwanyane. Ubuntu translates into humanness, okay? And Ubuntu is recognized when seen, and although not easily defined. Look at what Mohammed J, again in Mokwanyane. It expresses the ethos of an instinctive capacity for an enjoyment of love towards fellow men and women. Look at Justice Sachs, again in Mokwanyane. He says Ubuntu envelopes the key values of solidarity, group solidarity, compassion, respect, human dignity, conformity and basic norms, and collective unity. Look at another case, S versus Walters. He argued that Ubuntu creates a deadly force case. It had a deadly force case where Ubuntu demands proportionality, that forward-looking preventive justification for state force, retributive justifications are actually incompatible with Ubuntu dignity. And then the significance becomes heavily important, because now we know that this is something good and African in the context of how it can be played out for the sake of African jurisprudence. Now, for those of you who may be in Zimbabwe or may want to know something about Zimbabwe, we could also argue that the Zimbabwe's constitution and customary law engagement with Ubuntu, noting the foundational, it was heavily noted in terms of the founding constitutional sentiments, especially drew on what they call communitarian African values. And I analyze how these Ubuntu principles are shaped in terms of the formation of the Zimbabwean constitutional order and how the subsequent political developments tested the question of Ubuntu idealness in terms of governance, accountability, community welfare, and even individual power retention. No question about that in terms of that. And then in terms of other jurisdictions, I survey also other applications, talk about Kenya, for example, talk about Malawi, for example, talk about Tanzania, for example, talk about other areas in terms of what some other Pan-African countries in terms of how they address the concept of Ubuntu jurisprudence across those jurisdictions, because they are heavily manifest as well. And then in terms of how it has actually grown internationally, we could also look at it in terms of the bigger aspects, in terms of including communities that are, for example, if you look at the management theory provided by Kasten and Lear, in terms of the UK argument, it became what they call a community coercion policy in terms of that. And then the global resonance supports the other arguments that I'm talking about. Ubuntu has now become a universal purchase. It's not limited to African societies, but speaks in terms of a fundamental human value that actually transcend cultural specificity. So the aspect of universality versus cultural specificity is actually something that is also important. But Ubuntu, in this context, claims universality by grounding rights in the capacity for communal relationship, a capacity that all human beings share regardless of culture. So my argument is that Ubuntu, therefore, provides a non-Western but generally universal foundation for human rights discourses, and one that neither mimics Western liberalism nor retreats into cultural relativism. So that's fundamentally important in terms of, again, the discussion of the concept of this wonderful subject of Ubuntu. I'll go straight to section 7, where I said I'll talk about some challenges and some criticism in that aspect. So in terms of the argument here, we are saying we're not void of substantive weaknesses. I confront them directly, and I give substantive defenses where applicable. In terms of the uncoded practice, for example, we have so many concepts where someone would argue they are unrecorded in terms of practice. Yes, Ubuntu is based largely on oral tradition and unrecorded customary practice, making it difficult to establish within precision required for formal legal systems. I will give that as well. In terms of insufficient sensitization, also there is insufficient information dissemination and sensitization about Ubuntu philosophy in public and even legal institutions. I also give that to them. And in terms of association with obsolete practices, yes, I would argue that Ubuntu philosophy is sometimes negatively associated with obsolete African traditional virtues, customs and practices. For example, the female genital mutilation, if you like, forced marriages, witchcraft accusations that may violate contemporary human rights standards. We'll give that to them as well. How about in terms of proliferation of foreign ideologies? I would argue that, yes, Western liberalization, for example, market capitalism and even globalizations have actually displaced Ubuntu values in many African communities, particularly in urban settings, making its applicability increasingly counterculture. And then in terms of anti-modern critique, some thinkers argue that Ubuntu is an anti-modernist. It represents outdated values and stands in the way of efficiency and development. And that was propounded by Heston and Hostrick in terms of that argument. Then you could argue in terms of the management fad risk. In management discourse, Ubuntu has actually been reduced to flavor of the mouth, status, undervaluing its philosophical depth, and that is something we may want also to think through. And then you could also argue as another challenge in terms of the shadow side of Ubuntu. I think it was Swaz and Davies who argued that they identify the shadow of the shadow side of Ubuntu when individuals must actually forsake personal needs for the group. Resentment festers, for example. The dominant groups uses shaming as a control mechanism, constraining innovation and even individual potential. And then the aspect of collectiveness versus individual rights. The fundamental tension, of course, does exist amongst those, and Ubuntu communal emphasis can actually be used to suppress individual rights in the name of collective conformity. A risk in terms of which I intend to address, by the way, through Getch's restricted communitarianism, as I'm just propounding. And then the aspect of non-uniqueness as an argument. We are saying that there's a question of Ubuntu's uniqueness or ununiqueness. We are saying that it's arguing that many elements of the effective community, for example, or democracy or citizenship or civil society are universal and not Ubuntu specific, and that overemphasis on culture specificity may actually limit a wide application. We are mindful of that, and we shall also correct that in terms of that. So those are fundamentals in terms of what we have just discussed here. In terms of the argument of whether or not it is actually vague, in terms of an objection, we construct it in a way that we provide a precise moral standard, the promotion of communal relationship grounded in shared identity, solidarity, and mutual care. And in terms of the collective objection, I just argued in terms of Getch's restricted communitarianism that has actually been deployed. And in terms of other things like maybe associated with harmful practices, yes, Ubuntu does not protect harmful customary practices, it actually prohibits them. And any cultural practice that values human dignity is anti-Ubuntu. However traditional may actually be, so we're saying that cases like Aboki, like FIDA versus Uganda, demonstrate that distinction explicitly. And so even if the values are not entirely unique, their cultural rootedness in Ubuntu communities give them that legitimacy and the resonancy that extremely imposed frameworks lack. So authentic legal development requires indigenous jurisprudential foundations as another component in terms of that discussion. Now, in terms of Section 7, in terms of the recommendations that have to do with and then perhaps normative proposals, we are saying that the central recommendation perhaps would be that suitably interpreted through the lens of restricted communitarianism be adapted in terms of a ground of public morality and foundation for human rights interpretative in terms of Uganda. So the argument here that the courts do require to read constitutional rights through the lens of communal solidarity, through dignity as relational capacity and restorative rather than simply purely retributive justice. That is fundamentally important in terms of that. In terms of the spectrum for specific recommendations, court legislators, for example, and administrators should actually adopt Ubuntu as an explicit normative framework, particularly for constitutional interpretation under Article 126(1). And then in terms of politics, we could also argue that and economics, for example, Ubuntu should actually inform restrictive policies, the communal ethnic demands that wealth not be centered in ways that destroy the community solidarity, fundamental as well. And then the Ubuntu philosophy should actually be a guide in terms of public education, in terms of training, in terms of institutional culture, instilling rational behavior focused through communal positive values, love, sympathy, kindness, sharing, and even respect. And then African Ubuntu collectivism should actually inform workplace relationships in terms of corporate governance, for example, in terms of CSR obligations, in terms of organizational culture, cultivating teamwork over individualistic competition, for example. And then the aspect that Ubuntu mandates an intergenerational respect and the value of elder wisdom, it becomes a resource for governance and community leadership that modern institutions have actually neglected. And then it's also important to note that Ubuntu demands that corporations see themselves as communal actors obligated to community welfare, not merely through shareholder returns. And then the aspect of transparency and accountability and communal welfare in governance are Ubuntu requirements, providing an African philosophical foundation for anti-corruption reforms as well. Talk about aspects, the aspect of the Ubuntu global gift. We are noting that Ubuntu as an African jurisprudential gift to the whole world. It becomes a non-Western but universally applicable framework for human rights and enriches global legal discourse. And then in terms of recommendations, in terms of an adoption of a jury system, for example, for the sake of Uganda, as an Ubuntu-informed reform, juries, for example, represent a communal conscience in criminal adjudication, embedding community values in terms of responding, and that their decisions are actually not taken note of and do affect the final decisions in terms of the fate of an individual, rather than leaving it to simply advisors. And then the aspect of sentencing guidelines also, it should actually be reformed to harmonize the Ubuntu philosophy, prioritizing rehabilitation, restoration, communal integration over purely punitive measures, fundamental in terms of that. And then the aspect of the recommendation that have to do with the question of death penalty as an incompatible component of Ubuntu's restorative philosophy within the human right, dignity, and even relational capacity. So, and then the aspect of the Ubuntu should actually be recognized as a formal basis in terms of mitigation when it comes to sentencing, and also communities' restorative efforts, and also community understanding to weigh in terms of sentencing decisions. And then the aspect of governance in terms of national unity, in terms of merit-based appointments over patronage, and in terms of inclusive political processes that reflect Ubuntu governance as an ideal. Fundamental in terms of that. Now, when you go to section 7, the anticipated challenges would I probably want to handle them in my next booklet, because those are not very useful for me now, because they are more like reflective, they are more like conclusions, which I can handle in my next booklet, because I had quite a lot, and so it's very important for me to go through all of them without losing anything. The video may be a bit long, but rightly so, and importantly so, because it's important. We cannot run away from some of these wonderful things that we're trying to discuss here. Okay, so let me try to flip through again through this other document as I try to clean the sweat that is here with me. You bear with me, because yeah, it is normal to sweat. You know, I told you this is something we've done for about 9 years now, and so it is. It has its toll on us. Now, when you look at the aspects, some people do want to compare. Maybe before I go to that, but I would like to argue in terms of the constitutional architecture, which I think I presented. In terms of the foundations of the 1995 Constitution, I remember I talked about initially, but in terms of an apex, or perhaps a summary of sorts, we pointed it out from Article 1.1 that vests all the power in the people of Uganda, not individual citizens, not the state, but in the collective community of persons that constitutes the Ugandan appointed in terms of that. And then in terms of Article 8A, that was inserted by the Constitution Amendment of 2005, that established the national values and principles of governance that include unity, peace, equality, democracy, freedom, and social justice in terms of progress. So the enumeration of unity and social justice as an operative constitutional values is the direct initiation of Ubuntu communal ontology. So unity is not the unity of uniformity, but the Ubuntu unity of persons, constituted through their mutual relationship, social justice, not simply liberal repetitiveness. Okay. So now we also look at Article 21 as well. Look at Article 21 that provides the aspect of equality in terms of guarantee. Article 24 in terms of dignity protection. Article 32 in terms of affirmative action mandate. They all create that foundation. Article 24, prohibition of torture, degrading treatment. All those are fundamentals in terms of that. Article 32 in terms of the positive publication of affirmative action is the constitutional expression of Ubuntu in its most demanding moral principle. So, and then when you look at Article 126.2D, the textual cornerstone, perhaps the most textually explicit Ubuntu norm in the 1993 Constitution, and also which actually mandates that courts shall actually subject to the law to apply the following principles. The aspect of reconciliation between the parties shall actually be promoted, and then the provisions of extraordinary, the aspect that this provision creates an extraordinary argument in the sense that the common law tradition, so no inherited English constitutional framework contains a reconciliation mandate, no precedent in Uganda colonial legal inheritance provided for. So you want to look at that, but you also want to look at Article the argument of Article 126.2D also uses the aspect of mandatory shall rather than the permissive may, and this is constitutionally decisive. So courts do not have a discretion to promote reconciliation; they have an obligation. So this obligation created, currently is discharged, or if all, though the thin procedural expedient of mediation referrals is constitutionally grounded in Ubuntu substantive philosophical tradition, fundamental as well. Let me just take some little water. Okay. I knew that it would be a bumpy ride because this is fundamentally a serious business. And then the national objectives and directive principles in terms of the Ubuntu social architecture. The national objectives and directive principles in terms of state policy are actually the Ubuntu social architecture in terms of the 1995 Constitution. Particularly, if you look at Objective 1, it mandates the common good as the governing principle of state action. Objective 2 imposes an active duty to promote unity and even welfare on all the people of Uganda. Objective 24B requires the state to do what? To actually ensure that all Ugandans enjoy these rights, opportunities, access to education, stuff like that. And then Objective 22 mandates that cultural and customary values are actually consistent with the fundamental rights and freedoms of the Constitution and shall be given expression of the law. And then Objective 22 is particularly significant because it's explicit in terms of constitutional license of Ubuntu's legal operationalization, if you like. So the Ugandan expression of Ubuntu will, for example, or Matoputo, Ubuntu, or whatever, or Gachacha, or Harambe, are actually cultural and customary in terms of the customary values that actually are not repugnant to constitutional fundamental rights framework that Constitution therefore mandates to be given expression in terms of the law. So the failure to develop this expresses not a constitutional discretion, it's actually a constitutional failure in terms of that. And then the enabling legislation for Ubuntu statutory presence, for example, we looked at the Judicature Act already, CAP 13, which becomes the primary the primary statutory bridge between customary Ubuntu traditions and the formal adjudication. Section 15 directly directs courts, for example, to apply customary law insofar as it's applicable and not repugnant to justice, equity, and good conscience. Read through the Ubuntu interpretive lens, this provision inverts the traditional interpretive hierarchy that has actually subordinated customary values to imported liberal justice standards. So if Ubuntu constitutes the justice and equity, that's 15 that it invokes, then my argument here says it does. And then the customary Ubuntu principle are not filtered through the liberal justice, but actually they themselves are standards of justice by which the legal outcomes are actually assessed. So again, if you look at Section 14, in terms of the judicial, actually it preserves the jurisdiction of local council courts, which operates predominantly through Ubuntu-based community deliberations. In terms of conscious thinking, in terms of relational repair, and look at the Local Government Act as well. It similarly institutionalizes Ubuntu-grounded communal governance through village to village or district privileging, providing a statutory recognition of Ubuntu in terms of institutions that remain operational in terms of viability in Uganda today. Then other acts like the Land Act, then the aspect of dispute resolution, we shall get to that. And there's a misnomer in terms of thinking they are the same, but we shall talk about that as well briefly. And then the unnamed jurisprudential undercurrent that we're thinking about in terms of the hidden aspect. The most analytically significant dimension of Ubuntu position in Uganda today is that it characterizes an unnamed jurisprudential undercurrent in the courts. So an examination of the Uganda's constitution and higher court jurisprudence, particularly from 1995 to the present, reveals this consistent pattern. Courts reach outcomes consonant with Ubuntu reasoning, outcomes that protect communal belonging, rational dignity, and reintegrative potential and constitutional remedies, but they arrive at the outcomes through a non-Ubuntu doctrinal apparatus, leaving the constitutional obligations of Ubuntu reasoning undischarged and even jurisprudence incoherent in terms of its foundation. So that again is the fundamental in terms of the problem that we're trying to filter out here for us this evening. And then the aspect of the problem in terms of the Ubuntu's jurisprudential deactivation, perhaps you could argue that in terms of the deactivation. We are saying that the constitutional interpretive failure in terms of the positivist grip, because we see that there is a positivist grip in terms of constitutional dispensation as it stands today. The central jurisprudential problem identified by me is that Uganda is constitutionally present, yes, but jurisprudentially deactivated as far as Ubuntu is concerned. So the mechanism of deactivation is a question of legal positivism, and the methodological inheritance created by Lord Maclaren in terms of the colonial epistemide, or in terms of the epistemicide, which trained successive generations of Ugandan lawyers and judges to treat law as a closed textual system, answerable only to those hereditary superior rules and precedents, not to the philosophical foundation of the community of the law as we know it, or as it should be used to govern our country in terms of that component. So the point here, my friend, is that the foundational statement of Uganda constitutional interpretation is as provided for by Justice Udo Udoma in terms of the case of Uganda versus Matovu, that the constitution must actually be construed broadly and liberally. So this purposive mandate endorsed by the very subsequent Ugandan Court of Superior Court is systematically ordered in the breach when Ubuntu values are at stake. Now we are saying that the broad and liberal reading in terms of article, for example, what? In terms of article 126.2d, in terms of the reconciliation mandate, should on Matovu's own interpretive principle generate a substantive Ubuntu theory of adjudication. Instead, the provision has actually been treated as a thin procedural reference to mediation. We're getting to the serious problems here, and this is the point I'm trying to underscore here. When you look at cases like Attorney General versus Nyenfriza, the Supreme Court held that the Constitution must actually be interpreted as a whole, with each provision illuminating the other, and that the purpose and spirit of the Constitution must actually guide its application. So the Ubuntu spirit of Constitution, embedded in Article 1, or in Article 8A, Article 24, Article 32, Article 126.2d, the preamble and the national objectives, has never been identified and systematically deployed as an interpretative lens that Nyenfriza holistically mandates and demands. Problems, my friend. When you look at cases like Paul Pahanga Sevogere versus Attorney General, the Supreme Court affirmed that the preamble is an operative part of the Constitution informing the interpretive of substantive provisions. The preamble's commitment to building better future grounded in Uganda's past. It's an acknowledgement of historical struggles of the Ugandan people and its aspiration as a policy that honors their values and provides a direct Ubuntu entry into the constitutional interpretation. Yes, the courts have never drawn this connection. That's what you're saying. Listen, when you go ahead and talk about what I would argue as a jurisprudential audit, and in terms of the case law, perhaps that play out, when you look at Abuki in terms of the question of the Ubuntu result without Ubuntu reasoning, the concept of Ubuntu result without the Ubuntu reasoning, in terms of the jurisprudential audit. In Salvatore Abuki versus Attorney General, the Constitutional Court struck down the witchcraft banishment provisions as unconstitutional, holding that they violated Article 24, Article 26, 27, 29, 44 of the Constitution. Justice Oda, concurring, opinion, reasoned that communal belonging is constitutionally protected because the right to remain within one's home community is intrinsic to human dignity. Fundamental, not so. So the reasoning is substantially Ubuntu. Banishment severs the person from the web of relationship, from their family, from their clan, from their community. That constitutes their personhood under the Ubuntu ontology. So a person banished from their home district under the Witchcraft Act was not merely physically displaced, they were actually ontologically diminished, severed from the relational fabric in which the Ubuntu teaches or reaches their very personal, subsistence. And the court reached the Ubuntu outcome in terms of the protection of communal belonging, but without the Ubuntu reasoning that would have given the outcome its deepest justification. The doctrinal constance is that the subsequent courts had no Ubuntu framework built on. They only had scattered dignity ruling. Do you get my drift? Fundamental and extremely important. Let's look at Susan Chigula, for example. If you look at Susan Chigula, yes, we're doing a jurisprudential audit. Look at Susan Chigula in terms of the individual sentencing without rational theory. Yes, in Susan Chigula and 14 others versus Attorney General, the Supreme Court held that the mandatory death sentence was unconstitutional. It required individualized sentencing, and the court reasoned that the mandatory nature of the penalty, its insensitivity to the individual circumstances of each accused, violates Article 21 and 24 of the Constitution. In terms of Ubuntu criminal jurisprudence, it is grounded in Article 126.2d. Yes, in terms of the reconciliation mandate and the national objectives reformative justice principle. That would have actually deepened this reasoning substantially. The Ubuntu framework would have actually required the court to ask not only what the accused individual circumstances, but what they are, the relational consequences of the penalty for the accused family, for the community, and for the victim family. And how can the constitutional duty of reconciliation be discharged through a sentencing decision? This This rational inquiry was not wholly absent from the court's reasoning, which borrowed international human rights framework rather than deploying the Ubuntu resources embedded in Uganda's own constitution. You get the drift? We're proceeding. So the comparison of for example, the case of Jackson Mutwe versus Uganda represents a modest advance. And the Court of Appeal, for example, in terms of the invocation of reformative justice as a sentencing principle, gestured towards an Ubuntu integration as a principle. But the reformative justice in the court's usage was a borrowed rehabilitative psychological framework rather than an Ubuntu rational theory grounded in constitutional mandate as provided for under Article 126(2)d. The gap between the constitution requires and what the courts deliver remains fundamental. The gap between what the constitution requires and what the courts deliver remain. When you look at the case of Mifumi, yes, Uganda, in terms of Mifumi, the Ubuntu values were assessed through a non-Ubuntu standard. Mifumi, in terms of the litigation, yes, the spanning both in terms of constitutional courts, especially in 2010, and the Supreme Court in 2015, the most sustained Uganda judicial engagement with custom that is directly Ubuntu in the social function, especially as far as the bride price was concerned, the argument of Umtwaro, is the communal acknowledgement that a marriage relationship, the mechanism by which the two families and through them two communities formalize the rational bond or relational bond. It's not a commercial transaction for the purchase of one person. It is an Ubuntu ceremony of a communal recognition. We shall give that to them. So both courts assessed bride price exclusively through the liberal rights framework as provided for under Article 21, asking whether the custom that treats women as individuals equally with the men, without engaging the internal Ubuntu normative logic of the practice. So the Ubuntu question, therefore, whether the custom promotes rational dignity, communal responsibility, and mutual recognition of the families involved, was in this case entirely foreclosed by the imported liberal framework. So the methodological error is precisely what this argument I'm presenting identifies. Ubuntu values are treated as potential limitations on individual rights rather than independent constitutional values with their own normative logic and their own constitutional standing under Objective 22. We get the drift. Let me go to another case in terms of further equality without relationship, in terms of without rationality. When you look at FIDA Uganda versus Attorney General, the court's gender equality analysis engaged with customary social engagements but assessed them entirely through Article 21 as in terms of equality framework. Ubuntu's alternative approach in terms of assessing customary practices by reference to their capacity to promote rational dignity, community responsibility, and the integration of marginalized members was absent. The court's treatment of Ubuntu type communal values as potential limitations on individual rights rather than as an independent constitutional value is the structural jurisprudential error that requires across this case law. And that is something, again, we have to be very careful about. When you look at Kanyamunyo, in terms of the question of Ubuntu discretion without Ubuntu doctrine, Kanyamunyo and another versus Uganda, the High Court invoked the accused family relationships in terms of the community ties and social integration was constitutionally relevant factor in terms of the bail determination, yes? But this is structurally Ubuntu reasoning. The court assessed the accused relational personhood, his embeddedness in a web of communal relationship that gave both liberty, social meaning, and also imposed social accountability on its exercise. But the Ubuntu vocabulary was entirely absent. The reasoning was anchored in an explained judicial discretion, yes, a feel of the relational dimensions of the case, rather than the constitutional obligation imposed by Article 126(2)e or 2d, and the Ubuntu values embedded in the national objectives. So the consequence is that the Ubuntu reasoning in Kanyamunyu cannot be built upon consequent courts, yes, and it cannot be cited as an authority as an Ubuntu-based approach to bail because it does not identify itself as such. The Ubuntu reasoning has no jurisprudential feature in that context. So fundamentals, again, in terms of that. When you look at the statutory failure, again, in terms of the penal code, in terms of witchcraft as an Ubuntu law, for example, the most direct site of tension between colonial positive law and the Ubuntu jurisprudence in Uganda at the statutory level is in terms of the penal code and the code's mandatory sentencing framework of capital offenses, for example, although partially dismantled in light of Chigula, but still operative in many provisions, is a statutory embodiment of the anti-Ubuntu punishment theory, and it forecloses, it has to be foreclosed in terms of that, in terms of trying to address that particular aspect. where again you could also look at the Witchcraft Act, the aspect of whose banishment provisions were actually struck down in Nabucco verses that represented the colonial legal system most direct assault on Ubuntu foundational principles in terms of the communal belonging. So the act survived in Uganda state books until today, in terms until the constitutional challenge was actually required to remove the most egregious provisions as measured in terms of the depth of the colonial positive inheritance, but it seeks to be dismantled in its entirety. And if you look at things like the Succession Act again, we are saying that in terms of the former inheritance law framework similarly failed to accommodate the Ubuntu principle that property passes through a webs of communal obligation rather than merely through testamentary will. And the tension between the act in terms of the individualized succession model and the communal inheritance practice of Ugandan communities, including the clan-based arrangement that the Supreme Court engaged in civil versus gender, a persistent site of Ubuntu's judicial suppression. Fundamental in terms of that. What then is wrong with some of our literature? If you look at some of our literature, I may not go so much into them, but I'll argue a few of them. You see, the most consequential failure of the existing literature in terms of the development is the failure for the development of specific Ugandan Ubuntu jurisprudence. Yes, if you look at what Professor Dr. Kabumba says, Kabumba's constitutional law scholarship represents one of the most significant Ugandan contribution in terms of this field. His identification of Ubuntu Bulam, for example, as embedded but inactivated by the 1995 Constitution, and his characterization of its absence from constitutional jurisprudence is curious and consequential lacuna, and they're the strongest statements in Ugandan academic literature in terms of this particular, which this particular discourse intends to address as well. Yet not even Kabumba's work, which in terms of he acknowledges that its immediate predecessor does not develop the doctrinal bridge from Ubuntu philosophy to constitutional adjudication. He argues in terms of the decolonization scholarship, he identifies the educational system as the primary mechanism in terms of Ubuntu suppression, but does not produce the doctrinal tools in terms of the interpretive principles or constitutional standards in terms of remedial frameworks as well. And that would allow Ugandan courts, to operationalize the concept of Ubuntu without waiting for educational reforms or even working through the system. So the broader aspect here, the broader Ugandan legal academy has actually, with negligible exception, produced no sustained scholarly work on Ubuntu jurisprudence. And the dominant approach treats the positive common law framework as settled and even adequate methodology in terms of many Ugandan constitutional interpretations of Ubuntu, to the extent that it appears at all. So it's treated as a subject of customary law courses rather than Ubuntu, not to the extent that it appears. So all this is treated as a subject of customary law courses rather than a constitutional law scholarship. So this discussion in my context would be essentially pioneering in the context of what I'm trying to present for. So those are fundamental issues that I wanted to discuss again for us here. Okay, I will try and again take us through certain aspects. I will not go through the moral question in terms of because those I briefly hinted, and then perhaps what is important is the Mamdani warning in terms of the colonial distortion of customary law. The existence of literature on customary law and Ubuntu in Uganda must actually be read with Mamdani's warning in family in view. In terms of the colonial administration did not simply ignore African customary law. They actually codified and instrumentalized it, and transforming flexible communal Ubuntu norms into rigid hierarchical structures that served indirect rule rather than the philosophical value of the communities from which they were actually derived. I think that is also very strong in terms of what that gentleman said. But perhaps also, if you look at Sesanti in argument of the decolonial challenge, institutionalization or irrelevancy, Sesanti in 2025, in terms of that, he argues in terms of the contribution that delivers the sharpest challenge to the inadequate Ubuntu scholarship. In terms of Ubuntu's decolonial potential is the only realizable if it is actually institutionally embedded, not merely rhetorical. In the formal structures of law and governance, Ubuntu invoked as a cultural supplement, a vague aspiration, as a motivational philosophy for communal harmony is not Ubuntu jurisprudence at all. No. It's actually Ubuntu domesticated by the very colonial epistemology that seeks to dismantle it. And Sesanti is reliable because he actually brought out that component why the Ubuntu was not eminent in the 1996 South African Constitution. So if you apply that in terms of the Ugandan situation, the scientist challenge means that there is no Ubuntu legal scholarship that fails to produce concrete doctrinal tools for institutional deployment inadequate to the task. So the Ubuntu interpretive principle that I am presenting proposes in terms of a design precisely to answer this challenge. So it is not a philosophical gesture towards Ubuntu, but a doctrinal framework for the systematic institutional deployment through Uganda's existing constitutional and statutory architecture. Very, very important in terms of that takeaway. And then in terms of the Ubuntu interpretative principle as a new dispensation, I talked about some of those theories, including the Dworkin transformative communitism and Geiche. So I will not go through those again because I think I have labored enough in terms of talking about some of those aspects in terms of the takeaway. Perhaps what I want to talk about now in terms of the next discussion is perhaps in the next document, because I said and promised that we are going to go through fire and serious discussion here, so that we are seen to be able to present a serious discussion as far as Ubuntu is concerned. So what then is important for us as perhaps another final discussion as we get into the middle and mid ends of our discussion? I may want to ignore this a bit because this may not be very relevant for me here. But perhaps, as I told you last time, maybe in terms of making the dispensation, in terms of the distinction, so that we can also understand the distinction perhaps between Ubuntu and ADR in terms of that, because the critical distinction becomes extremely important. The critical distinction in terms of the procedural Ubuntu versus the constitutional Ubuntu. And then does ADR make the constitutional dispensation argument mutable in terms of that as well? Those are fundamentals as well. So those are fundamentals in terms of what needs to be understood as well. So when you look at the framing of the tension in terms of the discussion between ADR and the constitutional aspect of Ubuntu, you have to be very careful, because lest you may think they are one and the same. The inquiry in terms of this is on surface, you could ask whether ADR in Uganda is an expression of Ubuntu, but beneath you will be careful to note that there are more consequential disprudential challenges. So if ADR already operationalizes the concept of Ubuntu within Uganda's legal system, does the constitutional dispensation therefore carry any water in terms of that? But you have to understand that the answer carelessly is to either underappreciate ADR in terms of a genuine Ubuntu resonance, or to catastrophically concede the central argument of in terms of labor built over years. So my analysis here is refusing those concepts. It's argued on the fact that with granular attention in terms of Ugandan jurisprudence, ADR and Ubuntu share a lot of resemblance, but are not constitutively identical, and that ADR Ubuntu consonant is procedural and contingent, whereas the constitutional dispensation demands Ubuntu's constitutionalization as a substantive, permanent, and even pervasive normative anchor, so that it becomes serious stuff here. So when you're looking at Ubuntu as a framework, first of all, I will not go through so much, because I know I've talked about rational personhood, I've talked about restorative over distributive over communal dignity, and then the ones that you're talking about, when you go to the aspect of the architecture of ADR, before the philosophical analysis can proceed, please understand that Uganda's ADR landscape must actually be mapped with precision. It's not monolithic. For example, you could argue in terms of court annexed mediation. The Judicature Act, in terms of the mediation rules, for example, they introduced court annexed mediation as a mandatory step in terms of civil proceedings before the High Court and even commercial court. Particularly look at Rule 4. It provides that the scheduling conference and then the register shall fix the matter for mediation, and the Rule 11, a settlement agreement reached has force as a consent judgment. So the commercial court practice direction as well, and subsequent iterations embedded mediation even more deeply into pre-trial procedure, reflecting the judiciary's recognition that adversarial trials are necessary in terms of that, and therefore are not necessary anymore, but can be dealt away by way of creating these quick justice deliverers but they're variable tools that can actually help us to reach quick justice. So when you look at the Arbitration and Conciliation Act, in particular Cap 4, you could argue that the legislation, which was originally enacted in 2000, revised until 2010, provides the framework for domestic international arbitration and conciliation. When you look at conciliation, particularly under Part 4 of Cap 4, is particularly Ubuntu resonant. So the conciliator does not impose decisions, but assists parties to reach mutually acceptable sentiment, preserving the relationship and dignity. Yes? When you look at the Small Claims Procedure Act, for example, the act that establishes a simplified procedure for claims not exceeding 10 million with mandatory mediation before adjudication. The magistrate conducting small claims proceedings actually explicitly empowered to encourage settlement at any stage. When you look at the local council courts, for example, in terms of the provisions of the Local Council Act, you will look at you will see that the adjudication also takes place in terms of land disputes, customary matters, family disputes. The courts operate largely through communal-based dialogue and what consensus presided over by elected community members rather than trained lawyers. When you look at traditional and cultural justice mechanisms, for example, those are beyond formal ADR. Uganda recognizes operates several indigenous justice systems. Like I told you, the aspect of Matoput, for example, they talk about the Kakoke mandate, where large communities assemble for deliberation and even conflict resolution among the Choli, for example. When you look at the Rotkwe under the mediated councils in Lango, for example. When you look at clan courts across Baganda, Sebasoga, Banyoro, the Ankole, they are presided over by these clan heads, the so-called Batakas, in terms of also and the clan heads by the Batakas, and then the applying of customary law in terms of family and land and succession disputes. So these are not merely informal. The provisions under the Judicature Act and the customary marriage, for example, also implicitly recognize their outputs, and courts have actually repeatedly, deferred to these clan-mediated settlements in terms of that as well. But listen, the case for ADR as Ubuntu, where the resonances are actually real, is what I want to look at now. Intellectual honesty demands that we must state the strongest version of the argument that ADR is Ubuntu before we dismantle it sufficiently. So, in doing that, I would argue and say there is shared restorative architecture. The most powerful point of convergence is restorative intent. Both Ubuntu jurisprudence and ADR, especially in terms of mediation and traditional processes, are actually oriented not toward a legal victory, but one party, but toward repairing what has actually been broken. Then, if you look at the LC courts and Ubuntu proximity, then you could see that the LC court system is perhaps one of the structurally Ubuntu institution in terms of Uganda formal legal structure. So we are saying that that's also relevant in the context of that. When you look at Matoput in terms of Ubuntu as the most authentic expression, Matoput is arguably the purest legal expression in terms of Ubuntu in Uganda, because it addresses the same justice questions between that Ubuntu actually addresses. How do we restore relationship after grievous harm? How does community heal? How does one reintegrate the wrongdoer without destroying the accountability? How about things to do with post-conflict issues? All those are usually captured in them. And when you look at that, particularly in the case of the post-conflict Northern Uganda context, in the case of Thomas Koyelo versus Uganda constitutional petition. Remember that the Constitutional Court grappled directly with the tension between the international crimes divisions, retributive framework, and the constitutional and the community demanded for Matoput in the best rated justice in terms of, and then Justice Remy Kasule, and then people like Alphonse Owiny-Dolo, as it was then, and others acknowledge the legitimacy of traditional justice mechanism, even if the court, ultimately deferred to the formal criminal framework, as it were. So you look at the mediation in terms of a win-win, the Ubuntu relation, in terms of the ethics, all those are provided for. Now, the case against ADR as Ubuntu, in terms of as a critical limit, ADR in Ubuntu is in form, but not in foundation. That is something very, very important as well, also for us to comprehend. ADR is Ubuntu in form, but not in foundation. So the most fundamental distinction in this is that Ubuntu is a philosophical and constitutional value. ADR is a procedural mechanism. They may produce similar outcomes in particular cases, but their normative foundations are entirely different. ADR was introduced in Uganda as a judiciary primarily for efficiency reasons, not particularly to reduce case backlog, cut judicial costs, accelerate dispute resolutions, by virtue of the judicature mediation rules that were, promulgated against the backdrop of judiciary groaning under the case backlog over many, perhaps over 130 cases if you look at the Royal Report Commission way back. So the motivating philosophy was managerialistic, not Ubuntu. So the fact that mediation happens to generate outcomes consonant with Ubuntu does not mean that it's grounded in the concept of Ubuntu. So consider that analogy. The fact that a doctor, for example, gives a patient bed rest because the hospital is actually overcrowded, and this rest, happens to promote healing, does not mean the doctor acted from the philosophy of holistic care. So the outcome may actually be the same, but the animating principle is entirely different. Constitutional Ubuntu requires that the animating principle, not just the outcome, be Ubuntu. The distinction has direct jurisprudential consequences when you look at the case of Attorney General versus Major General David Chinyere. The Supreme Court actually affirmed that constitutional interpretation must be purposive and value-laden. So courts must actually seek animating spirit of constitutional provisions, not merely their literary effect. So if ADR animating spirit is efficiency rather than Ubuntu's rational ethics, then ADR cannot substitute for constitutional Ubuntu, even where they produce the same outcomes. When you look at another issue in terms of ADR operates at the margins. Ubuntu must permeate the core, fundamental, because ADR in Uganda, for example, is structured as an expression of dominant adversarial paradigms. So the baseline of Ubuntu's legal system remains the inherited English common law adversarial model as a model. Yeah. So the parties as opponents judge as an umpire, the winner and loser, aspects of punitive remedies, cost orders, etc. So all these things are vanquished one way or the other. ADR is permitted as an alternative, a decision from norm available in certain courts and certain case types at certain stages. Ubuntu jurisprudence demands that the inverse, in terms of the inverse, Ubuntu is a constitutional norm from which specific adjudication principles do flow. ADR cannot tell a judge how to interpret Article 20 in terms of the fundamental rights and even freedoms in a way informed by Ubuntu's community dignity. ADR cannot even guide the Constitutional Court in terms of assessing whether the piece of legislation actually violates Ubuntu rational personhood. ADR is a procedural option in civil disputes. It says nothing about constitutional rights, about education, about criminal sentencing, about philosophy, about economic rights, or even administrative justice. When you look at the case of Salvatore Boki versus Attorney General, the Constitutional Court struck down the witchcraft-related, exile provision of the Witchcraft Act as unconstitutional, degrading punishment. The court reasoned in this thesis, categorizing as which I categorize in my thesis, particularly as category 1, in terms of the Ubuntu reasoner, that the dignity of the individual cannot be reduced to their alleged wrongdoing. The community interest in terms of integration rather than permanent exile was implicit in terms of the court reasoning. So this reasoning could never have been generated by ADR. It required the constitutional analysis animated by Ubuntu values. So ADR simply had no jurisdiction over such questions. Then another issue that we may want to look at is the question of ADR in terms of Ubuntu's resonance is incidental and revocable. Yes, because ADR in Uganda is not grounded in Ubuntu. Constitutionally or even jurisprudentially, its Ubuntu consonant effects are incidental and revocable. The judicature mediation rules, for example, can be amended by the rules of committee under section, for example, 49 of the Judicial Act. They could tomorrow be amended to introduce evaluative mediation or even restrict mediation on purely commercial disputes or even make settlement agreements, unenforceable in certain categories. So none of these changes would actually require constitutional amendment because there is no constitutional Ubuntu anchor protecting the Ubuntu consonant character of the mediation framework. This revocability is jurisprudentially fatal to the argument of ADR, that substitutes for constitutional Ubuntu. The constitutional value cannot be protected by subordinate legislation. So the moment Ubuntu expressions in law depends on rules that can actually be unmade or made without constitutional amendment, Ubuntu exists at the pleasure of the Rules Committee. So a position entirely inconsistent with its claimed status of foundational African constitutional value, fundamentally in terms of that. So you compare that again to certain cases like the South African cases where Ubuntu is referred in the constitutional epilogue and has actually been incorporated in the constitutional court as a living constitutional principle. Look at S versus Manyani. It brings that. Look at Bay versus Magistrate of Kelbisa. Look at Port Elizabeth Municipality versus various occupiers. Look at Dikoko versus Moktala. All the things. For example, in Dikoko, Justice L.B. Sachs held that the defamation damages ought to have been assessed in a manner that actually enables the parties to restore the relationship. A directly Ubuntu informed remedy that actually had constitutional authority behind it. So Uganda's ADR framework lacks this constitutional grounding. It produces similar outcomes in some cases, but without normative authority, interpretive compulsion, and institutional permanency. And that is a big problem. Still, the component of another issue we could look at in terms of the colonization deficit. When you look at Ubuntu without liberation, ADR in Uganda, particularly court annex mediation, was designed within and reproduces the structures of a legal system that is fundamentally colonial in its structure already. The adversarial in trial and the professional monopoly in terms of justice delivery, the spatial organization of the courtroom, the formal rules of evidence, all these remain intact. ADR operates within the colonial architecture as a pressure, release valve, if you like. So Ubuntu's jurisprudence, as argued in the constitutional dispensation framework, is not merely about dispute resolution outcome. It is a civilizational claim, a claim that African philosophy values must reshape the foundations of legal systems, not merely decorate its edges. So the decolonization critique is precisely this: the incorporating African value into fundamentally unchanged colonial legal framework produces a sanctuary of transformation, not transformation itself. ADR, including Matoput, in its court adjacent form, risk the same, domestication, if you like. So when Matoput is recognized only insofar as produces, outcomes capable or acceptable, for example, to the International Criminal Crimes Division, as the Koyero case illustrates, this is not Ubuntu constitutionalized. It is Ubuntu tolerated within the colonial legal framework that reserves the right to override it, whether it conflicts with received international criminal law norms. This is the exact inversion of what constitutional Ubuntu dispensation would actually require. Fundamental and very important in terms of that. ADR cannot address Ubuntu absent harm in a constitutional adjudication. If you look at in my earlier discussions, if you remember the categorization of the three-case typology, I argued that the three category typology in Ubuntu doctrinal, my doctrinal argument would be that were relevant because, particularly under category 3 cases, Ubuntu's absence in terms of decisions with identifiable harm cannot be addressed through ADR at all. The harm identified in such cases is judicial reasoning that disregards relational context and communal dignity in a way that produces a result Ubuntu would prohibit. So this harm occurs in a reasoning of the court itself. In the constitutional or even common law framework, the court applies no ADR mechanism can correct this, by the way. So we have to understand that again as a fundamental in terms of that. The critical distinction in terms of the procedure, Ubuntu versus constitutional Ubuntu, very, very clear. Procedural Ubuntu is the set of dispute resolution practices in terms of mediation, in terms of conciliation, in terms of traditional ADR, LC courts, blah, blah, blah. Constitutional Ubuntu is the normative principle. It's anchored in the Constitution that all legal reasoning, rights adjudication, legislative design, executive action must be animated by Ubuntu values. It operates at a level of what law is for and what it means. It is universal in its application, entrenched against ordinary legislative change and civilization in its ambition. Very important for us to understand that. Okay, so those are important. So does it mean that ADR, make the constitutional dispensation argument a moot? Categorically no. And that's what I'm trying to answer here. ADR cannot provide interpretive anchor for the rights of adjudication. Look at the case of Mwanga Chivumbi versus Attorney General. The Constitutional Court held that provisions of the Police Act permitting detention of persons found in circumstances suggesting criminal intent violated Article 23 of the Constitution. A constitutionally embedded Ubuntu principle would have required the court to go further, to ask not only whether the detention violated a formal right, but whether it violated the rational dignity of the detained person, whether it damaged the community fabric, whether a restorative rather than a purely procedural remedy was required. ADR has no role in that case. Constitutional Ubuntu would have actually had a role in that case. When you look at the case of Sehel and 3 others versus AG, in terms of the constitutional petition. The Constitutional Court addressed material health care, and the right to health. A constitutional Ubuntu anchor would have supplied the court with jurisprudential tools to read Article 33 in terms of the rights of women and Article 45 in terms of the broader rights in a manner affirming communal obligation for maternal health. Ubuntu's understanding of health as a communal, not merely individual condition. ADR is relevant to this analysis. When you look at ADR, we're arguing also that ADR cannot constitutionalize the Ubuntu dividend. The Ubuntu dividend that I mentioned earlier in terms of my earlier discussions, the measurable improvement in terms of justice outcome attributable to Ubuntu consonant reasoning requires to be maximized that Ubuntu becomes comparison rather than optional element in terms of judicial reasoning. ADR makes Ubuntu optional in dispute resolution. It says if the parties choose, they may resolve this through a process consonant with Ubuntu with Ubuntu. Then the constitutional Ubuntu, on the other hand, says in all adjudication, Ubuntu must inform the reasoning. The difference between may and must, between choose and compelled, is the entire difference between procedural Ubuntu and constitutional Ubuntu. And then if you argue in terms of ADR cannot bind the legislature. Uganda's parliament operates under 1995 constitution without any Ubuntu interpretive constraint. Legislation can actually be and even regularly is enacted that is structurally Ubuntu hostile, individualizing land tenure in ways that fragment communal land holdings in terms of the Land Amendment Act, for example, criminalizing cultural practices that subvert Ubuntu restorative functions, creating punitive sentencing frameworks that disregard communal integration. No amount of court annexed mediation can actually constrain Parliament from actually enacting Ubuntu hostile legislation, because Parliament is bound by Constitution, not by the rules of committee. Only constitutional Ubuntu can reach Parliament's legislative power. Please remember that. So we could also look at further in terms of the case of Thomas Koreyo as a case of definitive illustration. When you look at Thomas Okoye versus Uganda, we are saying that this actually became the most powerful single piece of Uganda jurisprudence for this argument, because Koreyo, a former LRA commander, sought amnesty under the Amnesty Act of 2000. The Constitutional Court initially granted this, but on appeal, the Supreme Court reversed. So in Uganda versus Thomas Koreyo, in terms of the holding, that the Amnesty Act did not automatically apply and that international criminal law obligations potentially prevailed over domestic amnesty. What this reveals is the following: Ubuntu resonant option. Amnesty, restorative justice, community reintegrating through Matoput was available within the legal system, yet it was ultimately overridden by a formal legal framework that had no constitutional Ubuntu anchor. Had Ubuntu been constitutionally entrenched, the Supreme Court would have actually been required to weigh the constitutional Ubuntu value in its interpretative calculus, not merely permitted to consider the policy opinion. Okay, so the absence of constitutional Ubuntu meant that Matoput claims and the Ubuntu-based restorative justice demands of the affected communities in Acholi land had no constitutional standing. There were policy considerations, no constitutional imperatives. And this is the but-for test applied in the highest level of Ugandan jurisprudence, for the absence of constitutional Ubuntu. Chalewo's case might have been resolved through a framework that acknowledged Matoput as a constitutionally authoritative, not merely a culturally tolerable issue. That is something again important. So ADR cannot address structural violence as another component. Ubuntu's most radical jurisprudential demands in its challenge to structural violence, the system patterns of legal and even institutional design that damage community, perpetuate inequality and even frustrate human flourishing at the communal level. ADR resolves individual or small group disputes. It cannot address the Ubuntu hostile structure of the constitutional order that lack a constitutional duty of Ubuntu solidarity. It provides no Ubuntu-informed reading of economic rights. It fails to constitutionalize communal land tenure, for example, as an Ubuntu value, and offers no Ubuntu anchor for the interpretation of Article 21 in terms of equality in a way that accounts for communal rather than merely individual equality. Those are fundamentals in terms of the discussion that we're having. So the argument again, my friends, would be that the synergetic argument in terms of how ADR strengthens the constitutional legislation case is undeniable, but the two have also been discussed in terms of discussion. So we have to be very clear. So in short, is ADR Ubuntu? partly, but in its best expressions, authentically, no. Authentically, yes, but particularly traditional in terms of Matoput, in terms of LC courts, and in terms of facilitative mediation. So the resonance with Ubuntu's rational ethics and restorative orientation and communal harmony are genuine, but jurisprudentially insignificant in a way or the other. But why is it not fully Ubuntu? Because it is, its ultimating philosophy is efficiency, not Ubuntu, because it operates at a procedural margin rather than constitutional core, because it's Ubuntu, because its Ubuntu consonant effects are incidental and revocable, because it cannot bind courts in constitutional adjudication, or even parliament in terms of legislation, or even executive in terms of governance, and because it produces colonial legal architecture rather than decolonizing it. Okay, does, for example, ADR's Ubuntu consonant make constitutional dispensation argument unnecessary? Categorically no. And the reasons are not merely academic. We are saying Uganda's own jurisprudence way back from Abuki, and also Chelao, and also Shehad, and also Mwanga Chivumbi demonstrate with painful clarity that Ubuntu consonant outcomes are achievable but not guaranteed, recognized but not entrenched, available but not compelled. The constitutional dispensation argument addresses exactly this gap, the gap between a legal system that sometimes produces Ubuntu outcomes and one that is constitutionally bound to do so. Remember, ADR produces Ubuntu works. The constitutional dispensation argument demands that it must be made to work everywhere, always, for everyone, and not just a dispute resolution mechanism in terms of that. Very, very important in terms of that discussion. And those were important for us because we needed to understand the finalities in terms of the difference between Ubuntu and ADR. I promised a long ride. We are still proceeding because it's important, and we will try to again clean ourselves because we are sweating a bit, which is okay, and that's normal. This is serious work, as I promised you. Okay, I hope that I don't have to take you into complications, but try to make it as simple and as easy as possible. And when I realize that we have captured many of the things, then I'll tell you that maybe we may have to shift to the next gear in terms of that. And that's the reason why I'm trying to flip through here for purposes of as those things sink in, and then we see what happens. But this discussion is a very interesting one, and I think you have had a lot of beautiful information laid out for us so that we can know what and where to do. Perhaps one of the things that I need to have in the later discussions are the philosophies, the frameworks that have developed out of this school of thought, out of this serious work, what I would want to call the Rumogo frameworks of constitutional interpretation in certain aspects. And I will have a lot of analysis, grounded analysis, so that you know exactly what and how we made them and why we made them and how they were able to go through. Okay, for now, because of the depth of the length, I think we should probably pause here, and then we shall get back to the next video, where we shall be able to explain now those philosophies, the legal frameworks, the philosophical frameworks in terms of the framework, what I call the Rumogo frameworks of constitutional interpretation when it comes to certain fundamentals that have come to develop, especially out of these 9 years of trying to understand and study the concept of Ubuntu and the law towards a new constitutional dispensation. So I want to thank you for really holding on up to this time, and God bless. Thank you very much. Thank you.